So, good morning everyone. I, Rudraksh Vishwakarma, an intern at Law Minds. Today we're presenting about legal issues in data breach, response, and notification. So, now coming to the introduction. In a digital age, data breaches have become alarmingly frequent, posing significant challenges for businesses and government worldwide. The increasing reliance on digital platforms and exponential power in data generation have made data security a paramount concern. Data breaches can lead to substantial financial losses, damages to reputation, and potential legal consequences. The legal implications of these breaches are indeed complex and multifaceted. They vary significantly across jurisdictions due to differences in legal systems, cultural norms, and public expectations. In some jurisdictions, stringent regulations require businesses to implement robust data protection measures and mandate timely notification in the event of breach. Non-compliance can result in a severe penalties, including hefty, hefty fines and imprisonment. This article aims to explore the legal issues in data breach responses and notifications the perspectives from the perspective of international regulation and Indian law. It delves into the intricacies of legal framework, the obligation they impose on businesses, and penalties for non-compliance. The article also highlights the need for global cooperation in formulating and enforcing data protection regulations. Given the tra- transnational nature of digital platforms in data breaches, it underscores the importance of staying abreast of the evolving regulation in the domain, both at the international and national level, to ensure compliance and protection against potential legal repercussions. Now, coming to the international perspective of data breaches, data breaches defined as an incident where unauthorized individuals gain access to confidential data can have potentially disastrous consequence for any business. The immediate fallout of a data breach often includes hefty fines imposed by regulatory bodies and significant reputation damage. However, these are just the tip of the iceberg. The long-term effects of a data breach can be even more devastating. The a breach can be a, a breach can lead to loss of customer trust, which can result in decreased businesses and revenue. It can also expose a business to potential lawsuits from affected customers. Furthermore, a data breach can hamper a business commercial recovery and its position in the marketplace. The cost of remediation, including strengthening security infrastructure and systems, can be can be substantial. The cost additionally businesses may face increased insurance premiums and may struggle to secure future coverages. Notification requirements in the events of a data breach. These there are several legal implications enshrined in data protection law across all jurisdictions. A company that has suffered a data breach is required to notify all affected individuals as soon as possible. The, this requirement is based on the principle of transparency and the right of individuals to be informed. The notification should include details of the breach, the nature of the data compromised, and the measure taken by the company in response. In most cases, the company must also notify the regulatory authority. This allows the authority to assess the severity of the data breach, the risk of individuals, and whether the company has taken appropriate measures in response. The regulatory authority can provide guidance and enforce actions if necessary. Under the General Data Protection Regulation (GDPR), The Information Commission's office ICO uh, must be notified within 72 hours of the breach being discovered. This requirement underscores the urgency of responding of data breaches. Failure to notify within this timeframe can result in penalties, highlighting the importance of having effective data breach detection and response procedures in place. The role of GDPR in this. The GDPR, which came into effect in the European Union in 2018, has significantly changed the international landscape of the data protection. It has introduced stringent requirements and hefty penalties, thereby raising the stakes for businesses handling personal data. The GDPR requires businesses to implement robust data protection measures and mandates timely notification in the event of data breach. It also empowers individuals by giving them greater control over the personal data. Under the GDPR, businesses are required to adopt a proactive approach of data protection. They must implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk. This includes measures to detect, prevent, and respond to data breaches. Now coming to the Indian perspective on data breaches. The current legal framework governing data breaches in India is the Information Technology Act of 2000. This act was one of the first attempts by the Indian government to regulate cyber activities and protect their data privacy. Chapter 9 of the Act specifies the penalties, compensation, and adjudication of various cybercrimes, including data breaches. However, the Act has been criticized for its lack of specificity and clarity, particularly in relation to data breach notification requirements. Recognizing the need for more comprehensive data protection legislation, the Indian government recently unveiled a draft of Digital Personal Data Protection Act (DPDPA). DPDPA on November 18, 2022, the DPDPA represents a significant step forward in India's data protection landscape. It introduces several new concepts and principles such as data minimization, purpose limitation, and storage limitation, which are in line with international best practices. One of the DPDPA, once the DPDPA is passed in the parliament, it would effectively replace the current Information Technology Act. Now, the notification requirement under the DPDPA is the event of personal data breach. The data fiduciary, the entity that determines the purpose and means of processing personal data, is required to inform each affected data principals, the individual to whom the personal data relates, and the protection authority. This represents a significant departure from the current IT rules, which do not explicitly require data breach notifications. The specific format and method of reporting are yet to be prescribed in the DPTPA. However, it is expected that the notification will need to include details of the nature of the person data breach, the number of data principals affected, the possible consequences of the data breach, and the measures taken by the data fiduciary to mitigate the effects of the data breach. Personal data breaches personal data breach is broadly defined under DPDPA Act as in as any unauthorized processing of personal data or accidental display, acquisition, sharing, alteration, destruction, or of loss of access to personal data that compromises the confidentiality, integrity, or availability of personal data. This broad definition is intended to cover a wide range of scenarios and ensure that all the significant data breaches are reported. Now, Coming to the conclusion to this, indeed, uh, indeed, the legal landscape surrounding data breach, response, and notification is dynamic and continues to evolve in response in the increasing frequency and complexity of data breaches. Both international and Indian regulation underscores the importance of timely notification and transparency in the event of data breach. These regulations not only serve to protect the rights and privacy of individuals, but also aim to foster a culture of accountability and responsibility among businesses. They emphasize that businesses must take proactive measures to safeguard sensitive data and respond promptly and effectively when breaches occur. However, compliance with these regulations is not just about avoiding penalties, it is also about building trust and confidence with customers and stakeholders. In the digital age, data security is not just a technical issue but a business imperative. A robust data protection strategy can enhance a business reputation, build customer trust, and ultimately drive business growth. Moreover, these regulations highlight the need for businesses to adopt a global perspective on data protection in today's international world. The data breaches in one jurisdiction can have implications across implications across borders. Therefore, businesses must stay abreast for not only the regulations in their home country but also international data protection laws. In conclusion, navigating the legal issues in data breach response and notification requires a deep understanding of the regulatory landscape, a commitment to data protection, and a proactive approach to risk management. As the stakes continue to rise, businesses must rise to the challenge and ensure they are prepared to respond effectively to data breaches. This will not only ensure compliance with regulations but also protect their reputation and promote trust in the digital age. Thank you.